We are very delighted and honored to have the Assistant Attorney General in charge of the Criminal Division of the U.S. Department of Justice. One of the most important positions, I believe, in government because of the authority and role that they have on the judicial system, on the lives of individuals, both victims and defendants. And it is a role that has been entrusted to Nicole, who has joined us this morning, who is here bringing her view from the position she now holds, but also a lengthy and substantive career as a prosecutor in Brooklyn. She's also been in private practice. So she has walked both sides of this journey that we're all on together. We're very delighted to have her here today, and I will turn over the podium to her.
Good morning. Thank you for that kind introduction. I have to say I'm very glad about the order this morning, because after hearing about the hypothetical, it's bringing back memories of law school, and I'm going to be departing before then. Tips, I think if you sit in the back, you get called on first. It's an honor to be with you all here today. I'm very grateful to have this opportunity to discuss the important work that the Criminal Division is doing day in and day out to combat white-collar crime, both at home and internationally. There are many new and exciting developments in international white-collar enforcement. And you'll hear about many of those developments, and you have been over the past few days from the world's foremost experts, whether it's cross-border law enforcement cooperation, extradition, economic sanctions. And it's thrilling that you're hearing about all of these issues from different perspectives, from prosecutors and regulators to defense counsel and in-house lawyers at major corporations. So I'm thrilled to be a part of it, and with my time here today, I'd just like to discuss 4 areas with you. First, the Criminal Division's commitment to combating white-collar crime and protecting financial markets, which we can only do through our deep and ever-growing international partnerships. Second, recent changes to the Department's corporate enforcement policies and how we at the Criminal Division are implementing them. Third, I'd just like to touch for a moment on the Criminal Division's important work related to task force klepto capture, to enforce the economic sanctions the United States has imposed in response to Russia's invasion of Ukraine. And finally, just a brief look to the future. So let's jump in. The Criminal Division has a broad mandate to tackle all forms of crime, whether it's committed by violent gang members on the street or corrupt executives in the boardroom. While our mission is broad, prosecuting white-collar and corporate crime is one of our top priorities. We do that by holding accountable both individual wrongdoers who undermine the integrity of our financial markets and the corporations who often benefit from their crimes. In particular, our fraud section focuses on the integrity of our markets, rooting out a wide array of misconduct, from cryptocurrency investment schemes to securities fraud that harms innocent investors. In April, prosecutors in Fraud's Market Integrities and Major Frauds Unit, MIMF, we love acronyms in DC, secured a guilty plea from Sterling Bancorp for making materially false statements in its initial public offering and other public securities filings about its marquee lending program, a program that, unbeknownst to the public, was rife with fraud. In keeping with our commitment to protecting financial markets and investors who rely on the fair functioning of those markets, Sterling was required to pay more than $27 million to non-insider victim shareholders. And in keeping with our #1 priority in this area, the 3 individuals who were responsible for the underlying fraud scheme have also been prosecuted and convicted. Our commitment to protecting markets also includes holding accountable financial institutions, along with their officers and employees that undermine the security of the U.S. financial system. The Bank Integrity Unit, BIU, within the Criminal Division's Money Laundering and Asset Recovery section, or MLARS, we're just going to keep these acronyms coming, has long focused on the threat posed by financial institutions that flout U.S. anti-money laundering laws and economic sanctions. With roughly a dozen prosecutors over the past 10 years, the BIU has imposed more than $13 billion in financial penalties in criminal resolutions with global financial institutions that engaged in anti-money laundering and sanctions violations, those prosecutors punch well above their weight. To strengthen those efforts, earlier this year, we announced a surge of resources to the BIU, which will add 6 prosecutors to target economic sanctions-related financial misconduct. This investment shows we are willing to put our money where our mouth is. But the department will not succeed in combating white-collar crime on our own. As you all know, white-collar crime knows no borders. Criminals involved in investment frauds, bribery, sanctions violations move across international borders, as do the illicit proceeds of their crimes. To effectively fight these offenses, strong partnerships and cooperation with our international counterparts is mission critical. Working with foreign authorities allows us to be force multipliers. It makes evidence easier to obtain, it leaves criminals fewer places to hide, and it helps us recover criminal proceeds wherever they may be found. International cooperation also amplifies the deterrent value of corporate prosecutions. Companies and their employees should understand that now, more than ever before, law enforcement partners around the world are working together to tackle complex financial crime. As our recent cases show, we are regularly working with large numbers of foreign law enforcement partners, not only in FCPA matters, but across the full range of our investigations. And our footprint of successful partnerships continues to grow. In recent years, we've worked with our enforcement colleagues all across the globe, including, of course, here in the UK, but also in Brazil, Malaysia, Singapore, Switzerland, Ecuador, France, South Africa, Colombia, and more. We forge these relationships not only by cooperating in cases, but also by working together in critical international organizations. This week in Paris, 2 of our fraud section prosecutors are participating in the Organization for Economic Cooperation and Development's working group on bribery, where they are meeting with foreign counterparts about existing and potential investigations. This coordination among international law enforcement partners is one of the most important developments in white-collar enforcement over the last decade, and it has produced real results. Last December, we announced the department's first coordinated resolution with authorities in South Africa. ADB agreed to pay over $300 million for bribing a high-ranking official at South Africa's state-owned energy company to corruptly obtain confidential information and to win lucrative contracts. And in August of this year, we continued to break new ground by announcing the first ever coordinated resolution with Colombian authorities in a foreign bribery case. Corfi Colombiana, a Colombian financial services institution, agreed to pay over $80 million for participating in a scheme to pay millions of dollars in bribes to high-ranking government officials in Colombia. The Corfi Colombiana resolution also illustrates how we are implementing some of the recent changes to our corporate enforcement policy, the next area I wanted to discuss with you today. As you all may know, in January of 2023, my predecessor, Assistant Attorney General Kenneth Polite, announced the first substantive changes in 5 years to the Criminal Division's Corporate Enforcement Policy, or the CEP. The CEP sets forth specific benefits for companies that voluntarily self-disclose misconduct, fully cooperate with our investigations, and timely and appropriately remediate misconduct. One of the goals of these policy changes was to allow prosecutors to make finer distinctions between companies that do the right thing and those that fall short, both in terms of the form of the resolution and the amount of the fine. Under our previous CEP, the maximum credit available to companies that did not voluntarily self-disclose misconduct, but fully cooperated and timely and appropriately remediated, was a 25% reduction from the low end of the fine range. The recent revisions increased that cap to a 50% reduction. Now keep in mind, every company still starts with 0 cooperation credit. By increasing the maximum amount of credit a company can receive, we are not grading on a curve. It's not grade inflation. The new policy is meant to more greatly reward good actors, not companies that just do the bare minimum. Simply responding to legal process, standing alone, not cooperating. To earn credit, we expect companies to truly cooperate in our investigations. We expect them to be both responsive and proactive. And do not forget, the fine reductions account for both cooperation and remediation. With Corfi Colombiana, the first case announced under the new CEP, we awarded a 30% reduction to recognize its efforts on both fronts. The company not only took significant cooperative steps, it also took significant remedial steps. Among other things, it conducted a root cause analysis of the misconduct and promptly took actions to enhance its corporate governance and controls at joint venture entities. It overhauled its compliance program and established a disciplinary process overseen by a cross-functional ethics committee. In addition to being the first FCPA case under the revised CEP, the Corfi Colombiana resolution also implemented the new requirements in the criminal division's compensation incentives and clawbacks pilot program. That's what we announced last March. The first part of the clawback pilot program underscores the department's view that corporations should have compensation and bonus systems that reward behavior consistent with compliance values. Under this part of the pilot program, every corporate resolution involving the criminal division will require that the resolving company include compliance promoting criteria in its compensation and bonus system. As part of its agreement with the department, Corfi Colombiana pledged to do just that, but also consistent with local labor laws. We want you to know that we appreciate that relevant labor and employment laws and other laws across the world vary, and so the pilot program takes that into account. And as the language in our policies and the resolutions make clear, those agreements are subject to such laws. The second part of the pilot program provides clear and predictable monetary incentives for companies to claw back or withhold, I should say, compensation paid or otherwise due to individual wrongdoers. This applies to employees who engaged in suspected wrongdoing in connection with the conduct under investigation, or had supervisory authority over those who engaged in the misconduct, and knew of or were willfully blind to the misconduct. Indeed, companies will be able to reduce criminal penalties when they attempt in good faith to claw back or withhold compensation, even if at the end of the day those efforts are unsuccessful. The pilot program provides that for every dollar that a resolving company recoups from a wrongdoer, whether through money that's withheld or paid and then clawed back, the otherwise fine for the conduct will be reduced by $1. This is a double savings. The company not only receives the benefit of not paying a wrongdoer, it also is rewarded with an additional dollar-for-dollar fine reduction in its resolution with the department. The program also recognizes that clawing back compensation can be timely and complicated, and that clawbacks may not be complete at the time of a resolution. In those circumstances, the resolving company will pay the fine at the time of the resolution, minus a reserved credit equal to the amount of the compensation that the company is actively attempting to claw back. Once the company completes the clawback, the corresponding amount will be released from the credit to the company. And even if a company is ultimately unable to achieve the clawback, prosecutors have the discretion to credit the company's good faith effort by releasing up to 25% of the amount that the company tried to claw back. Our recent resolution with Albemarle a few weeks ago is a good example of how we're implementing many of the policy changes I just went over, including the pilot program and the CEP. So in that case, Albemarle, a publicly traded chemicals manufacturing company, entered into a 3-year non-prosecution agreement with the FCPA unit in fraud to resolve foreign bribery charges. The company admitted to agreeing to pay bribes to government officials to obtain and retain business with state-owned oil refineries in 3 countries. And the bribes were paid through third-party sales agents and subsidiary employees. The company agreed to pay a penalty of approximately $98 million and to forfeit approximately $98 million in ill-gotten gains, also simultaneously resolving with the SEC. How were our policies put into action? First, let's take the clawback program. Albemarle, like Corfi Colombiana, agreed to implement compliance-related criteria in its compensation structures subject to local labor laws. In addition, we awarded our first ever penalty reduction under the pilot program because the company withheld bonuses totaling over $700,000 during the course of its investigation from employees who were covered by the policy. Because Albemarle had proactively implemented measures to freeze future bonuses for those suspected of misconduct, they were able to withhold such compensation rather than have to claw it back. And they were rewarded with a reduction in their criminal monetary penalty equal to the amount of the bonuses that were withheld. Now let's turn to the CEP. Albemarle was awarded a 45% reduction from the low end of the penalty range. That's the highest percent reduction under the revised CEP to date. Albemarle substantially cooperated with our investigation. They also undertook significant remediation. The company created extensive enhancements to its corporate compliance program, particularly regarding its third-party due diligence and monitoring. The company literally transformed its business model and risk management process to reduce corruption risk and to embed compliance in the business, including by eliminating the use of sales agents throughout the company. The company also terminated hundreds of other third-party sales representatives, such as distributors and resellers, and shifted to a direct sales business model. These improvements carry significant weight with us because we encourage companies to invest in effective risk analysis, risk mitigation, and compliance programs that help prevent misconduct from occurring in the first place. But I really want to emphasize what set Albemarle apart from many other companies. It voluntarily disclosed the misconduct before the conduct came to the department's attention. Now, the company was not reasonably prompt in that disclosure as defined under the CEP. They learned of the allegations regarding misconduct in one country approximately 16 months before disclosing it to the department. And then after an internal investigation, the company gathered evidence related to the potential misconduct at least 9 months prior to making the disclosure. Taking too long to self-report meant the company was not eligible for the greatest benefit under the CEP, a declination. But as they say, better late than never. The company's decision to come forward, even if belatedly, resulted in significant and concrete benefits, including benefits that would not have been available under the older version of our policies. For one thing, the company resolved the case through a non-prosecution agreement rather than a deferred prosecution agreement or a guilty plea. And within the new range of 0 to 50% reduction under the CEP, Albemarle's decision to disclose factored heavily in our decision to award a 45% discount off the low end of the penalty range. The previous maximum discount under the old policy would have only been 25%. We know the decision as to self-report misconduct is a difficult one for companies and their counsel. But remember the benefits that await you if you choose to do the right thing. The business case for compliance is clear. As department leaders have repeatedly emphasized, we greatly value expediency and then can offer a presumption of a declination if the voluntary self-disclosure is reasonably prompt. This allows us to move quickly, to gather and preserve evidence, and enhances our ability to charge culpable individuals. But it's not an all or nothing proposition. Don't let the passage of time alone dissuade you or your clients from coming forward. As the Albemarle resolution shows, even a belated self-report can result in significant and meaningful benefits. As I expect our future resolutions will show, the same is true of cooperation and remediation. Earlier is always better, but even late-stage cooperation and remediation is better than none. Let me now turn to another focus of the criminal division that involves significant coordination with international partners, Task Force Klepto Capture. Attorney General Garland announced the formation of Task Force Klepto Capture in March of 2022 to ensure that oligarchs feel the full impact of the economic sanctions that the United States has levied in response to Russia's invasion of Ukraine. Strong international cooperation has been essential to the task force's work, from collecting key evidence to seizing assets funded in violation of sanctions. But pursuing kleptocrats with the assistance of our international partners is not new to the criminal division. MLARS established its Kleptocracy Asset Recovery Initiative more than a decade ago to target and forfeit the proceeds of foreign official corruption. Task Force Klepto Capture builds on those efforts. In the past year and a half, the task force has aggressively pursued its mission, and through MLARS, the criminal division has helped lead that charge. Task Force Kleptocapture has leveraged the Kleptocracy Initiative's expertise in complex financial international investigations and asset forfeiture to use all available tools to target those who support Russia's aggression in Ukraine. Among other successes, this team has seized a $300 million luxury yacht owned by a sanctioned Russian oligarch. They have obtained seizure warrants for 2 jets associated with oligarchs and their entities. And in the last month, MLARS, along with the Department's National Security Division and our U.S. Attorney's Office partner, secured the guilty plea of 2 individuals who engaged in a scheme to violate sanctions imposed against a Ukrainian oligarch for his misappropriation of state assets of Ukraine. The president of Florida steelmaking company Metal House, along with his co-conspirator, transferred over $150 million to the oligarch in exchange for steelmaking products for Metal House. These defendants prioritized their profits over compliance with U.S. sanctions, and they paid a hefty price, pleading guilty to federal criminal charges. The task force will continue to work with our international partners to build cases against Russian oligarchs who violate sanctions imposed in response to Russia's unjustified act of war, and to seize and forfeit their assets. So we've clearly packed a lot into 2023. Significant policy changes, corporate resolutions, individual prosecutions, forfeiture actions, and more. And I expect the remainder of the year will yield even more corporate resolutions as our strong pipeline continues to bear fruit. But I am always looking to the future, when I expect you'll see even more activity in this never-ending fight against corporate crime. On the policy front, we will be implementing the new department-wide M&A safe harbor announced by the Deputy Attorney General last week. On the theme of earlier is better, this new safe harbor, which applies across the department, creates an incentive for acquiring companies to come forward to report misconduct uncovered during pre- or post-acquisition M&A due diligence. The incentive is a presumption of a declination for companies that disclose misconduct by an acquired business within 6 months of closing an acquisition. The acquiring company will also need to fully remediate within a year to qualify for a declination. As the DAG noted, these timeframes are baselines. They are subject to a reasonableness analysis because we realize that not every company and every deal are the same. I'm very proud to note that the Criminal Division has been a thought leader in corporate criminal enforcement policies. And over the last 2 years, Criminal Division policies regarding voluntary self-disclosure, monitor selection, and compliance have been expanded into the Justice Manual and extended and adapted by other components. The Safe Harbor policy likewise builds upon an existing provision in our Criminal Division CEP that we've used to great effect over the years. Let me just explain for a minute how the Safe Harbor policy will interact with our CEP. The CEP states that companies that uncover misconduct at an acquired entity through pre- or post-acquisition due diligence or integration efforts that remediate the misconduct, appropriately implement a compliance program, disclose the misconduct, and disgorge all ill-gotten gains will receive the benefit of a presumption of a declination. The recent declination for a French aerospace company, Safran, shows how this policy has been applied in practice. Safran acquired 2 companies in 2015. Through its post-acquisition due diligence, Safran learned that both had paid bribes to a close relative of a then senior Chinese government official. Safran received a declination, it earned it, by identifying the misconduct, voluntarily self-disclosing it to the FCPA unit, fully cooperating, remediating, and disgorging the ill-gotten gains. Under the new policy announced by the DAG, to the extent that companies were not already motivated to rapidly come forward to report misconduct uncovered in the M&A context, the message is clear. Companies will best position themselves for a declination if they move swiftly, within 6 months, if not sooner. And if they fall short, keep in mind the lesson of Albemarle. While early reporting is best, self-reporting late is always better than never, whether in the M&A context or otherwise. There are significant benefits under our policies in terms of both penalty reduction and form of resolution. We also expect the new Safe Harbor policy, in conjunction with the CEP, to increase our ability to both prosecute and prevent additional corporate crime. By encouraging companies to come forward and disclose, we will be able to hold wrongdoers accountable for crimes that were ongoing and undetected. We expect to receive information that will promote our department-wide goal of holding individual wrongdoers accountable. This will increase both accountability and deterrence. We see this new policy working hand in hand with the CEP as a way to incentivize companies to report bad acts that we would not otherwise know about. The criminal division's goals are also clear: to lead through both our enforcement and policy work in the areas of corporate and white-collar crime, and to have an impact that reaches far beyond any individual case, to encourage good corporate citizenship, to incentivize investments in compliance programs, and to further our primary goal of individual accountability, to generate policies that are both transparent and predictable so that we can effectuate real change in corporate behavior domestically, and to work with our partners to amplify that change internationally. Thank you so much for your time this morning.